I think we're live. Good afternoon, everyone, and welcome. Thank you for joining us today. My name is Sena Sahin, and I'm the co founding attorney at Capital Law Partners. We're a business litigation and immigration firm serving clients in DC, Virginia, and Maryland. And for immigration purposes, we offer services nationwide. I've spent the last 5+ years representing businesses in complex and employment adjacent disputes. And one thing I've learned is that the most expensive lawsuits are almost always the ones that could have been avoided with the right advice. So that's exactly why we're having this webinar today. And before we get started, a few quick notes before we dive in. So this is the YouTube Live. Please drop your questions in the chat as we go. We'll try to get to as many as we can. And today's session is general legal information and educational content. It isn't legal advice, and watching this does not create an attorney-client relationship. Of course, we have to give this disclaimer. So if you want advice on your specific situation, we'll share how to reach us at the very end of this webinar. So today, I'm thrilled to be joined by my friend and colleague, Abbas Sadiq. Abbas is a business and employment attorney licensed in Maryland and DC, with over 20 years of experience handling complex employment and labor matters. Before going into private practice, he worked at the U.S. Department of Labor, where he handled federal employment law, wage and hour regulations, and employer investigations. So he's seen these issues from the government side as well as the employer side. Today, he's the founder of Sadiq Law Group, where he advises businesses, executives, and employers on workplace disputes, compliance matters, discipline and termination, wage and hour issues, and risk management. And before we hand it over, I want to say Abbas and I have had the privilege of working together on several matters where business litigation and employment law overlap. And I can tell you from personal experience, he's exactly the person you want in your corner on these issues. Abbas, welcome, and thank you for being here today.
Thank you, Sena. I really appreciate it. It's an honor to be here today. And I've also worked with you on a few matters. It's been great. And I'm excited to address any of your questions and talk to the audience. Thank you.
Yeah, so here's what we're going to cover today. Employment law is one of those areas where small mistakes can lead to enormous liability. And we're talking about 6 and 7 figure verdicts, EOC investigations, Department of Labor audits, class actions. And the businesses that get hit hardest are usually not bad actors. They're just growing companies that didn't know what they didn't know, right? So, over the next 30 to 40 minutes, we're going to be discussing the most common mistakes that you see employers make, and more importantly, how we can avoid them. So, let's jump in. We'll get started with one of the biggest issues businesses face today. What is one of the most common employment law mistakes employers make that can expose them to serious liability?
That's a great question, Sena. Thanks for asking it. One of the biggest things is, as you said, as businesses grow and scale, a lot of times employers, they really don't have either the time or the bandwidth to document, employee performance, when employees start, when they stop, any issues of misconduct or performance concerns. So what I would say to answer your question, the number one thing that I see is lack of documentation. And we're all busy. Everybody's busy. We're running our business. You're a business owner, so am I. So frequently we just don't find time to document cases where maybe an employee did something which really doesn't reflect our business, or maybe they said something which we really don't think they should have said, or we may not even have time to always document their time. When did they come in? When did they come out? Or to tell them, hey, it's really important to document your time. So I would say the number one thing I see is lack of documentation. Because as a business owner, as a startup, as a growing business, we're focused on, the front end, recruiting business, maintaining business, growing our operation. So we feel like, oh, I'll do it later, I'll get to it later, and often we don't. So lack of documentation is the number one thing that I frequently see.
Yeah, I mean, that's very important. And do you think that this is something more common in companies of certain size? For example, startups or mid-market companies, or do you see it across the board?
I think it's really with startups. With established companies, I find they do have a system in place, and sometimes they may have a trusted HR partner, or they may use some type of time entry system, um, or they may even have an attorney on board. So with larger companies, I find this is less of an issue. They've kind of crossed this hurdle. But it's really with the startups or smaller companies that are really focused on growth. They're, as business owners, the owners frequently want to grow their business, establish, high quality or high caliber relations with other businesses, et cetera. So that tends to be the focus rather than, uh-oh, this person is not really reporting their time accurately, or this person is saying things that they shouldn't say, any and things like that. So it's really the smaller or mid-sized businesses that find this to be very common.
And that's a great foundation for the rest of our conversation. So let's drill into specifics. We hear a lot about businesses misclassifying workers as independent contractors. Why is this such a major legal risk, and what should employers be paying attention to?
Yeah, it's a huge legal risk. I have several clients who, as employers, unfortunately, they misclassify their employees. And it's common to happen because, again, for the same things we were just speaking about, because we're all so busy, it's like, okay, instead of signing on with a payroll company, let me just 1099, write a check, pay them based on their hours, and I'll deal with it later. Well, guess what? Later never comes. And frequently, what happens is there's two things. On the one hand, as business owners, when we do that, we're not paying the employees, like we're not paying their taxes, right? So a lot of times we need to correctly classify their unemployment taxes, their state taxes, their federal taxes. None of that is being taken out. So that's a problem from a regulatory side. And on the other hand, if they truly are employees, which could mean, and again, this is not legal advice, it's just generally, just some thoughts I'm sharing. Um, if they're furthering our business interests, in other words, we own law firms. So if we're hiring, suppose, employing a paralegal, it's hard to say that that person might be a 1099 versus someone who's, you know, taking out the trash or vacuuming the rugs. That's something that's outside of our scope of employment. So we need to be careful because we can expose our business to a lot of liability. So on the one hand, there's a regulatory component with the government, and on the other hand, there's a legal component where we could be violating laws, federal or state laws as well by the misclassification.
Yeah, and I think one thing to just be mindful of is that misclassification can sit dormant for many years before it blows up, essentially, right? So just because nothing is happening on that end today doesn't mean it's not a legal risk. So,
Absolutely. Yeah, absolutely. We've seen situations where, I've had it many times where business owners say, hey, this person and I, we worked great together. We were a team, and, we had dinner, we had lunch, we hung out, et cetera, et cetera. And then all of a sudden there's a fallout, and the employee or the contractor feels that there was something unjust, or wages were wrongfully withheld, etc. They seek counsel, and next thing you know, the business owner is facing a lawsuit from the employee or contractor saying, essentially it's like a wage theft claim. So we all need to be very mindful for that.
okay. So let's move from how people come in to how they leave. Many business owners struggle with employee discipline and terminations. What is one of the most common mistakes that employers commonly make when firing employees, or and how they can better protect themselves from wrongful termination claims?
I think really what I see is a lot of time owners don't focus on performance. So it's fine to terminate employees or to take disciplinary action, but as business owners, they need to focus on performance, not other factors. So a lot of times, the employer or the owner might find that, well, I just don't like this person. They're not doing their job. They're creating a toxic environment. So I always try to bring it back to the performance. Well, what is your business? Okay, you operate a shipping company or you have a warehouse and the employee's not being productive. They're not tracking, invoices of items that are being unloaded from the trucks or the warehouse, the stock in the warehouse is not being adequately maintain or document. Performance related discipline or termination, I think as long as there's enough documentation is fine. But a lot of times it ends up becoming an emotional, well, I don't want this person here. I don't like this person. They're just bringing me down. They're bringing down other employees, et cetera, et cetera. I would say the best advice is to stay away from that, focus on performance. As an attorney, that's my goal, is to try to bring the employer or the owner back to performance. What are your goals? What's the mission? Do you do shipping? Do you do cleaning? What is the focus of your business? And how is this person's performance affecting your business? I think as long as we stay in that area, we're okay. But a lot of times I find it becomes very emotional and it's like, I don't want this person here. I don't want to deal with this person. It's not really a performance issue.
Okay. And what if a business owner is about to fire someone, let's say tomorrow? What are the two or three things you would advise them?
I would say make sure there's documentation. Obviously, focus on the performance. Whatever your letter is or your reason for termination, it has to be based on performance. And then document it. Ideally, there'll be several instances. For suppose, for example, a warehouse worker. On this date in January, in March, in April, I told you, I emailed you and said, we weren't documenting our supplies, the warehouse supplies correctly. I emailed you, I gave you a chance to improve. I did it on numerous occasions. Yet, despite, these warnings, despite this counseling, you still haven't improved. And, your performance is adversely affecting the outcome of our business. I would say that's the ideal situation where we have documentation and where we can show that it's based on performance. I think that's the safest way to terminate someone. Of course, you and I both know as attorneys, we can't predict the outcome of any type of situation. But what we can do is we can advise our clients and say, well, this is the safest path. We don't know what's going to happen. We can't make a guarantee. But by following this, we think you will be protecting yourself and your business. I would say really documentation, and focus on performance.
Okay. So documentation is probably the buzzword for today's webinar, right? I mean, that's a theme that's going to keep coming up in employment matters in general. So let's now talk about another area where documentation matters just as much. Pay, right? Wage and hour lawsuits seem to be increasing every year. What are some of the most common overtime and payroll compliance mistakes employers make today?
Yeah, that's a great question. And I agree. I've seen quite an uptick in wage and hour, or they're commonly known as wage theft claims. Um, Again, I think it comes down to what we spoke about earlier, where there's really, business owners are very busy, so they may not always have a way to track what are the hours the employee worked. In other words, what are the days? When did they start? When did they stop? And ensuring that employees are not working more than 40 hours a week, or if they are, making sure they're paid properly. So I think that's the number one thing. Again, I think, as business owners, as startups, entrepreneurs, et cetera, we're very focused on growing the business. You often find like, oh, I'll just get to it later. Just tell me how many hours you worked, or I'll just pay you a certain number. And employees are also working hard. They're working very hard and they're sacrificing time from their family, from their friends, from their social life. to come and try to accelerate, support, and help grow our businesses. So we want to be sure that if they are working extra hours, whether that's a sales call, a phone call, driving from one site to another, unloading, loading, finishing an email, if there are any extra hours, we're capturing those hours and we're paying the employees for those hours. If we don't want to pay overtime, then we need to have clear guidance that tells the employees, look, you cannot work overtime. You're only allowed to work 8 hours a day, 40 hours a week, etc. We need a written policy. If not, then we need to be open to paying the employees for whatever hours they've worked, and that may mean overtime. So definitely, the laws are very strict in Maryland and DC particularly, because we want to make sure we're paying our employees correctly. I don't think any of us, as business owners, want to we don't want that sense that, someone has worked for us and we haven't paid them. I mean, that's not a good feeling. So in order to pay them correctly, we need to have a way to capture all of the hours and make sure that they understand what we're paying them reflects the hours they actually worked.
Mm-hmm. And you mentioned DC and Maryland laws. So, for growing companies, you start in one location, and the next thing you know is you're successful and the company keeps growing. So now you have employees working in multiple states. What should business owners should be mindful of when they have employees from different states?
Yeah, that's a great question. Frequently it does happen where, maybe you even have a remote employee in another state. Well, frequently states have different laws concerning what we would call wage theft. There is a federal law, the Fair Labor Standards Act, but states frequently have their own laws as well. And some states allow 3 times the amount of wages claimed, or some states may have 4 times. So it's important to have good guidance, whether that's through an HR professional or whether that's with an attorney, and to ensure that the business owner knows what are the laws for each state. So, for example, if a business owner, is based in Washington, D.C., but they have remote staff in California, well, California may have different wage and hour laws. And it's not uncommon for an employee to want to stay extra or work later. Like I said earlier, to finish that email out or to just, come back from the trip or the drop off, whatever it is. And we want to make sure these employees are paid and the time is actually accurately captured. So I think in that case, we need to have guidance from either an HR professional or an attorney who says this is what the wage and hour laws are for each state because it may vary.
Right, right. And Abbas, so you worked at Department of Labor for many years. From a regulatory standpoint, what triggers a wage and hour investigation in your experience?
It's a great question. So what I've seen is even from my own experience, whether at the Department of Labor or as an attorney in private practice, sometimes it could be what we spoke about, the misclassification. Um, Sometimes the state may audit a organization, a company, and they may want to look and see, well, look, for example, you have 100 folks and they're all 1099 contractors. Let's take a look and see what are they doing? How is that related to your business? And the state may disagree. And I've seen that happen with a client of mine where the state didn't agree in some cases, and the client had to go back and pay taxes on the alleged misclassification. So it could be triggered randomly.
Hmm.
It could also be triggered by an employee or contractor who feels they were misclassified and they're owed wages, they're owed additional wages for overtime, etc. So it could be triggered by, the regulatory agency, the state, or federal Department of Labor. They could do an audit and ask to explain, like, how are you classifying these employees? Or it could be from the employee who goes to an attorney or who goes to one of those agencies and says, listen, I was only paid for 40 hours as a 1099, but I actually was an employee and I worked 60 hours. So I'm owed additional money and I was misclassified. So it could be either way, but again, the key comes back to kind of the buzzword documentation, where the employer hopefully has clear records and an explanation. Because I think at least as an employer, if we could show we had a good faith reason to make the classification and we have proper records, that does a lot to show that we were trying to at least, we were doing our due diligence, we were trying our best to comply with the law as we understood it.
Yeah, thank you. And just as a reminder, these claims can quickly snowball into class action or collective actions, especially if you have sizable employees. So let's shift to another area employers regularly get wrong. Let's talk about accommodations and leave requests. What are employers getting wrong when it comes to handling ADA accommodations and FMLA leave?
Yeah, well, a lot of employers, like they're busy or they don't understand, as business owners, entrepreneurs, they may feel, well, I got through it, why can't the employee? And we all need to be mindful that, outside of work, our employees, have issues, right? Everyone has a social life, a personal life, family, social, et cetera, et cetera. And maybe they're going through things. It could be a medical, physical, it could be psychological, it could be a loved one, it could be a variety of things. So as business owners, we need to be very mindful of that and be careful. And I think we all want to we want to run a business, but we also need to be supportive of our employees. So if an employee says, listen, my loved one, my spouse, etc., is having a difficult time, I need to be available for them, take them to the medical appointments, take them to the hospital or whatever it is. Or I need time for my own, mental health, etc. We need to be respectful and supportive of that. So the federal standard is not that high. And generally, an employee asking for that time is sufficient. There are some forms online at the Department of Labor website, which could be downloaded. Generally, there's just a medical note with the forms. But the bottom line is we want to be supportive. And the key for the accommodation is if we can reasonably accommodate, like if it's a desk job and the person, for example, we're seeing where it's a desk job, office type job, and the person needs to sit for extended time. Well, I mean, it's probably not incompatible. Again, not legal advice, just high level discussion. Now, a warehouse job, if someone needs to be sedentary, maybe we can look at that. But if the medical accommodation is really something which the employer can reasonably do without essentially impacting the mission of their business, then my advice would be the employer should give it a try. Because otherwise they may be setting themselves up for a lawsuit for ADA violation. So again, it is kind of fact specific, case by case. But rather than saying, I don't have time with this, I'm not going to deal with it, my advice to the business owner or the employer would be to reach out to an attorney or reach out to a human resource professional and try to see what you can do to accommodate the employee. Even if you ultimately get to the point where, you say, we just can't do it. If you've gone through a good faith interactive process and you come to the conclusion after that we can't do it, that puts you in a much better place than just summarily saying, I'm not going to do it, I'm not going to try.
Yeah, and so what about employers who think they're too small for these laws to apply? Is that a safe assumption?
Well, again, it is a state by state situation, but
Hmm.
my advice would be is to take the high road, engage in the interactive process, make a good faith effort and try to engage with the employee, try to make an accommodation rather than focusing on, well, I'm too small, you don't need to worry about it. Well, I'm too busy. So in this case, the size of the employer may matter, uh, depending on the type of claim that the employee could bring. Um, but again, we're not going to get into all the legal specifics. But overall, I would just say, as you know, an employment law business attorney, and I think you could appreciate it too. It's better to make a good faith effort and try to accommodate the employee as much as possible. Engage in the interactive process and see what you can do. If it's not possible, I think that's fine, but I would say go through the process as much as you can. And then if it doesn't work out, at least you can say, well, I've tried.
Yeah. And it sounds like a lot of these issues that we've been discussing comes down to whether the company has the right systems in place.
Absolutely. Absolutely. We spoke about having a good payroll system where the employer can document when did the employee start work, when did they stop work, what are the days of the week, having a certification that the employer certifies that these hours that I'm submitting for pay are correct and accurate to the best of my ability. We also talked about having either HR or an attorney consultant on board to make sure there's an employee manual. We talked about a solid onboarding process. We talked about a solid termination process, disciplinary process based on conduct, based on performance. So yes, we definitely have talked about having a solid system in place because, you may be able to relate to this too, as a leader, that, we're also busy growing our business. We may not always have time to do these administrative functions, but it doesn't mean they're not important. It just means that we need to find someone who's competent, where we can delegate them and make sure they're being done correctly.
Yes. And now we're going to transition to a different topic. So, harassment and retaliation claims can be extremely costly and extremely. So, what are some proactive steps that businesses should take to reduce the risk of these types of claims?
Yeah, I would say the number one thing I think I see is frequently employees may want to file some type of claim, whether it's an EEO claim or whatever it is. But at that point, I think employers need to be very careful and not take any sort of adverse action. And again, consult with your attorney. This is not legal advice, but any sort of perceived adverse conduct after an employee files some type of claim, whether it's an EEO or ADA claim, can be perceived as retaliation, especially if they're close in proximity. So in other words, hypothetically, an employee files some type of claim, and the employer says, I'm going to get rid of this employee, or I'm going to actually reduce this employee's hours. It could be perceived as retaliation if it's close in proximity to when the employee made the employer aware of the, perceived violation. So I would say that is something that I see frequently where employers say, I just want to get rid of this employee, or what if I just tell them they're done or cut their hours? After the employer knows, the employee may bring some type of claim. I think that is a very common area. It's something where I would say highly, highly recommend talking to an attorney or talking to a seasoned HR professional. Um, Again, not legal advice, but it is something that we all need to be mindful of.
Yes. And you mentioned an EEO claim. So we may have listeners who are not familiar with it, maybe because they didn't have to deal with this. So could you briefly tell us what an EEO claim might be?
Sure. An EEO claim is it's a claim generally based on a adverse act for something which was protected in the law. For example, someone might allege, I didn't get a promotion, and I believe I didn't get the promotion because I'm a woman, or so gender is a protected area, or because I'm a person of color, or because of my faith, or because of my disability. So generally speaking, at a high level, mostly your federal and state law says, you can deny promotions or whatnot if it's based on performance. but you can factor in gender or race or sexual orientation, those types of things in those decisions. So if someone feels that I didn't get the promotion or I was terminated for one of the legally protected reasons, it could raise what's called an equal opportunity claim, EEOC, equal opportunity claim. Many states like Maryland or DC, they have sister agencies where those types of claims could be filed federal or state. So when an employee makes an allegation about that, then they can file a claim, and depending on the amount of facts and the process, the administrative agency can investigate. It could also result in a legal claim too.
And if a business receives an EOC claim or charge or demand, what should the business do immediately? And what should they
I
avoid
would
doing?
definitely talk to an attorney. Talk to a seasoned attorney who's familiar with these types of claims. It's not something to take lightly. Many times business owners think, oh, well, there's no merit to this. I'm just going to ignore it. Big mistake. Um, Talk to someone, whether or not you think it's serious. And then the other thing is do not delete anything. Any of the communications, any of the emails, and everybody has it on their phone, do not delete it. All of that information, mostly what I found is employees will keep it. So it's important to also the owner has it, business owner has it, so they can share it with an attorney. But my advice would be contact an attorney, do not talk to the employee, and do not delete any information.
And also do not retaliate against the employee. So,
Absolutely, absolutely, 100%.
what is the single most damaging thing you've seen a business owner do in the first 48 hours after getting a EOC charge?
I think sometimes they might, actually directly contact the employee and say, I can't believe you did that. We had such a great relationship. I did so much for you. I gave you clothes, I gave you food, I invited you to my house. These are things I've actually heard. I would say that's the most damaging thing. A lot of times, those, as you know, as an attorney, some things are considered admissions. When the employer says, I didn't mean for what I seem to be taken that way. I'm not a racist. I'm not sexist, et cetera, et cetera. Those are all considered admissions. Again, not legal advice, high level. Be very careful about that. Now, like again, as you know, everything's on your phone. People will record conversations. In some states, they're admissible, in others they're not. But still, it's embarrassing and it makes it much more complicated. So I would say do not contact the employee.
And I guess this kind of brings us to our final question, which I think would ties everything together. What is the single most important thing business owners can do today to bulletproof their business from employment law problems?
That's a great question. I would say have a seasoned professional on board, whether it's an attorney or a HR professional. And my advice would definitely be proactive. Everyone wants to save money and wait till something happens, but that actually can end up costing more money. I'm frequently contacted by businesses um, who misclassify employees or are served with a wage theft claim. Um, or have an EEO claim. And I find often that it could have been avoided had they talked to an attorney ahead of time, um, who would have been able to help them correctly classify the employee, or who would have been able to help them avoid the EEO claim, or maybe even settle it for a much lower cost. But a lot of us are unfortunately a bit short-sighted, and we think, well, I'm not going to spend money now. I'm not faced with any claim. And then later on, things snowball. What could have been a small settlement or what could have been an easy classification issue end up being a large misclassification issue for tens of thousands of dollars plus legal fees or an EEO claim which won't go away. A lot of those things could have been avoided by taking a proactive approach. Um, just like we invest in our business to grow, I think having an attorney or an HR professional on board is a worthwhile investment.
Yeah, I mean, that's excellent advice. And it's important to have this relationship with an employment lawyer before you actually need one. So we always talk about preventive health or preventive legal things, actions we can take. And for businesses, the most important one would be to have an employment lawyer, build that relationship, someone you can trust and consult before the problem gets messy, and invest in early training and, of course, documentation. I mean, as we mentioned earlier today, documentation is probably going to come into play for every aspect of any kind of employment dispute. And so before we open it up for questions from the listeners, one last question for you, Abbas. If you could put one thing on every business owner's calendar this quarter or this year, what would it be?
Yeah, I would say talk to an employment lawyer, and make sure that whatever you're doing now is in compliance with the laws, of your jurisdiction. Take that proactive approach, like we all, for example, want to go to the gym so we can avoid getting sick later, want to eat right so we can avoid, getting sick, or missing time from work, missing quality time with our family or friends. It's the same thing for our business. We need an employment lawyer on board who can make sure we're taking the proactive steps to avoid a catastrophic lawsuit or a nasty demand letter.
Yes. I mean, that's again excellent advice. So let me take a few minutes here to see if there's any questions from the chat. And if you have something that you'd like to add, please feel free. Okay, let's see. Here's one. What is the one document every employer should be able to produce on 24 hours notice?
That's a good question. I would say a timesheet of the employee. If you're an employer and you have an employee, you should be able to produce a record of that employee's hours. When did they work? For example, on Monday, they worked 8 hours, or on Monday, they started at 8 a.m. They stopped at 4:30 p.m. They took 30 minutes for lunch. I would say the number one thing an employer should be able to produce in 24 hours is a timesheet of the employee.
Let me see if there's any other questions. Let's see. I think that's all we have for today. I mean, you did a great presentation covering a lot of the most important topics that business owners might face. So, Abbas, I want to thank you. This was incredibly valuable. And the themes that we keep hearing today are clear. Classify your workers correctly, document everything, keep records of everything, including time records and timesheets of your employees, and build that relationship with the employment counsel before you really need one, not afterwards. So, if anything we discussed today raise a question about your own business, feel free to reach out. We're gonna drop Abbas's website link here in the chat, so you can contact him at Sadiq Law Group. And then if you have any business or commercial dispute matters, you can also reach out to our firm. Abbas serves clients in DC and Maryland. We serve clients in multiple states, including DC, Virginia, and Maryland. And you can always reach out to our team. Uh, I want to thank Abbas again for his time. If you have any last words before we close off, I'll leave it to you.
Okay. Well, thank you for having me. It's been a pleasure to be here and be a part of the Capital Law Partners team. And yeah, I wouldn't, I don't think I can understate the importance of having counsel, quality counsel, either an HR professional or a employment lawyer and take that proactive approach. Don't wait, because I see it all the time where people wait and they come last minute when they're already served with the complaint, or they have the nasty demand letter and they're scrambling to figure out what to do. And unfortunately, they haven't taken the steps required before that, um, you know, to protect their business, which we all work so hard to build. And if the steps aren't taken, it's very hard to defend the claim, and we end up just having a conversation about settlement rather than defending the merits of the claim. So take some time out, talk to a professional. We do offer consultations at Sadiq Law Group, and happy to talk to anyone who's listening today, or anyone and from your team as well. Thank you.
And please subscribe to the channel so you don't miss the next webinar. So thanks again, everyone. Don't forget to take care of your business. Your business will take care of you. Hope to see you next time.